Hi, this is Manjri Singh from Law School 101 and this is a video in the Legal Aptitude series brought to you by Law School 101 for CLAT aspirants. In this video, we will be covering law of contracts. The structure of this video is as follows. We will be doing introduction of concepts followed by elements of a contract, offer, acceptance, lawful consideration, lawful object, additional elements, some important points, and questions from CLAT 2017, ILAT 2017, CLAT 2016, ILAT 2016, CLAT 2015, and ILAT 2015. Let's begin. We will begin with some general information about contract law from the point of view of questions asked for testing legal awareness. Contract law in India is based primarily on the Indian Contracts Act of 1872. Most of the provisions are still in force to this date. Other sections have been repealed by other acts or guiding provisions. The Indian Contract Act is based on the principles of English common law. As we cover more contract law, we will address legal awareness questions. Now, what is a contract? Contract is an agreement that is enforceable in law. It is a legally binding agreement. It is an agreement against which both parties have the right to approach the court to seek relief, remedy, or performance if the other party so fails to perform their part of the contract. We will begin by understanding the elements of a contract. These elements make the contract legally binding. Essentially, these elements are the differences between a non-binding, non-legally enforceable agreement and a contract. For the elements, we've created two lists, primary and secondary. The primary elements are the main fundamental blocks that are required to make a contract, and the next three are further qualifications, though just as important. A contracts question is most likely to test you either all the fundamental elements combined to determine whether it is a contract or some application of further qualifications. All of these elements will be dealt with specifically in following videos, but in this video we will go over them briefly. The four elements of a contract are offer, acceptance, lawful consideration, and lawful object. The additional elements are free consent, competence to contract, and expressly void contracts. The first element is offer. An offer is a proposal. It must be communicated to the party intended towards and must be clear and specific. It should mention all the details such as the price, color, etc. It should be made with a view of obtaining the other party's acceptance to the offer. Offers can be written or oral, as so can be contracts. However, it is very important for the other party in the contract to have knowledge of the offer. If the other party performs an act unaware of the offer, it does not constitute a contract. Hence, knowledge of the offer is necessary. The party that makes the offer is referred to as the promisor or offerer. The next element is acceptance. Acceptance is an affirmative response by the party being made the offer. An accepted offer is then known as an agreement. Acceptance can be expressed or implied. Acceptance is required to be absolute and unconditional. An offer cannot be accepted by someone who is either unaware of the offer or to whom the offer was not made. Acceptance is required to be communicated to the offerer or promisor. The accepting party is termed as the offeree or promisee. The next element is lawful consideration. Now we have a party who has made an offer and another that has accepted. However, the agreement still requires lawful consideration to become a valid contract. Consideration is the act or abstinence or price for the promise. Consideration can be made in the past, present, or future. There are exceptions, cases where consideration is not a must. These will be discussed later. Generally, lawful consideration means consideration that has some value in the eyes of law and is not illegal. For example, selling a 10 lakh apartment for 1 rupee would not be lawful consideration. The next is lawful object. The object is the act or absence or the crux of the agreement. It refers to the substance of the offer. For a contract to be valid, the object of the contract needs to be lawful. For example, an offer to steal will not be a valid contract. This will also be dealt with in later videos. Now the additional elements. The additional elements are free consent. Both the parties in the contract must be free to accept or decline to the agreement and must accept the agreement voluntarily of their own free will. Competence to contract. The parties must be competent to contract. They must have the ability to enter contracts. Briefly, minors, individuals that are younger than 18 years, mentally unsound individuals, and persons specifically disqualified by law are incompetent to contract, and such contracts are not valid. The last is expressly void contracts. Some contracts are void by law itself. These will be discussed in later videos. Now let's discuss some additional points. Number 1. Offers can be general or specific. General offers are those that are made to the public at large, and specific offers are those that are made to specific individuals. In cases of general offers, acceptance can be implied from conduct and specific communication may not be necessary. The second point is, acceptance is complete when it is so communicated to the offeror when the parties are face to face. However, when they are distant, acceptance is complete for the offerer once the offeree has put the acceptance in the course of transmission such that it is out of the control of the offeree, and for the offeree once the communication of acceptance reaches the offerer. The postal rule. For example, if an offeree sends the acceptance in letter form, the acceptance becomes binding on the offerer once it is mailed by the offeree and out of the control of the offeree's control. The offeree becomes bound by the contract once the letter reaches the offerer. Now we can move on to some questions from previous year papers. Contract questions are frequently asked in papers, but we have only discussed those that are relevant to the concepts discussed in this video. The rest of them will be dealt with in subsequent videos. When you practice these questions, keep in mind the elements that we have discussed so far. Later, you will begin to consider these without effort. Also, remember to always strictly apply the principle given. Also, please pay attention to the explanations. You may turn on captions to see the explanations. We will begin with CLAT 2017 questions. The first one is, principle. Contract is a written or spoken agreement with specific terms between two or more persons or entities in which there is a promise to do something in return for a valuable benefit known as consideration. Such an agreement is intended to be enforceable by law. A unilateral contract is one in which there is a promise to pay or give other consideration in return for actual performance. Facts. A toilet soap manufacturing company in India, in order to promote the sale of their product, published an advertisement in all newspapers on January 1st, 2017, that the company has kept a model ignition key of an Audi A3 car. The advertisement also stated that whoever gets the said key before December 31st, 2017 from a soap bar will be gifted with the Audi A3 car. Mr. Martin, a foreigner who came to India as a tourist, who was staying in a hotel, found a key similar to the same car ignition key. Mr. Martin brought this to the notice of the hotel manager. The manager informed Mr. Martin about the company's advertisement on January 1st, 2017. Mr. Martin wants to claim the car. Will he succeed? The answer options are no, the soap company has not entered into a contract with Mr. Martin as he was not in India on January 1st, 2017 when the advertisement was published. The second one is no, actual intention of the company was to promote the sale of the soap. The third option is the hotel manager who could legally claim the car as he was the one who actually purchased the soap for use in the hotel. And the last option is Mr. Martin obtained the key before the stipulated date from the soap bar, so he is covered by the offer of the soap company and can claim the car. The correct answer choice is 4. The last option. According to the principle, the advertisement was a unilateral contract, consideration being the Audi A3 car in return for the performance of finding a key. The sales were promoted and this was the benefit for the soap company. Now the fact situation makes clear that getting the key suffices to fill the requirement. You may have realized that this is a general offer. As the foreigner is made aware of the offer by the manager and has the key, he can so take it to the company, thereby completing the performance to be entitled to the Audi A3 so long as this is before December 31st. The time period has not been mentioned. However, the other options give erroneous lines of reasoning and hence they can be eliminated. Any answer option that gives you extra information or goes beyond the principle is in all probability wrong. We can move on to the next question. Principle. An offer made by one party when accepted by another makes it a contract. Here are the following transactions. Number 1. P offered to sell his house for 20 lakh rupees to R. R told P that he was interested to buy a house for rupees 15 lakh only. The second transaction is C was looking for a house for not more than 25 lakhs. P informed C that his house was available for 20 lakhs. The third is K wanted to buy some old furniture. L told K that he would sell his furniture for rupees 10,000. The last situation is R advertised to sell his old car for a price of 3 lakhs. S found the advertisement and offered to buy it for rupees 2,50,000. R agrees to sell it to S. Now, which among the following is actually a contract? And the answer options are: number 1, situations 1 and 2 are contracts. Number 2, situation 4 is a contract. 3, situation 3 only is a contract. And 4, situations 2 and 4 are contracts. Acceptance needs to be absolute and unconditional. The correct answer option is 2. In situation 1, R does not accept the condition of rupees 20 lakhs and makes a counter offer. Hence, it is not a contract. Counter offer will be dealt with in the next video. In situation 2, an offer has been made by P, but it has not yet been accepted by C by making a communication. Hence, it is not a contract. In the third situation, L has made an offer not yet accepted by K. Hence, there is no contract. In situation 4, S has made a counter offer which has been unconditionally accepted by R. Hence, there is a contract. Now we move on to the next question. Principle. An agreement, the terms of which are not certain or capable of being made certain, is void. The facts are: Sundar agreed to take Bhola's penthouse on rent for 3 years at the rate of 12 lakhs per annum, provided that the house was put to repairs and the living rooms were decorated according to contemporary style. The answer options are: number 1, there is a valid contract because there is an offer from Sundar and acceptance from Bhola. Number 2, there is a valid contract because all the terms of the contract are certain and not vague, as the rent is fixed by both of them, and the term present style only can be interpreted to mean the latest style. Option 3, there is no valid contract because it is vague and has uncertain terms as per the present as the term present style may mean one thing to Sundar and another to Bhola. And the last option is, it is a voidable contract at the option of Bhola. The correct answer choice is option 3. A contract terms must be specific. Contemporary style is not only in itself vague, it is also incapable of being made certain. Hence, there is no valid contract. Had the parties decided on a particular design or color of repair or something more specific in nature, the contract would have been valid. Let's move on to the next question. Principle. Acceptance of a proposal must be absolute and unqualified. Facts. A made a proposal to sell his motorcycle to B for 25,000 rupees. B agreed to buy it for 24,000 rupees. A sold his motorcycle to C for 26,000 rupees the next day. B sues A for damages. The answer options are: number 1, B will get damages from A. Number 2, B will get the difference of rupees 1,000 only. Number 3, B can proceed against C. And number 4, B will not get any damages from A. The correct option is 4. A's offer is of 25,000, which is not accepted by B. Instead, B makes a counter offer of 24,000, which has not been accepted by A. Hence, there exists no contract between A and B. Therefore, A is free to sell his motorcycle because he is not bound to B. Hence, B will not get any damages because no contract has been broken, and nor did A owe any obligation to B with regards to selling of the motorcycle. Now, we move on to questions from IDA 2017. The first question is legal principle. The acceptance must be absolute and unqualified, leaving no ground for doubt or uncertainty. If the acceptance is conditional, no valid contract is formed and the offer can be withdrawn at any moment till the absolute acceptance has taken place within reasonable time of such offer. The fact situation is, Delhi government conducted an auction for the sale of license of a wine shop. X offered the highest bid, which was provisionally accepted, subject to the confirmation of Chief Commissioner, who may reject any bid without assigning any reasons. Since X failed to deposit the required amount, Chief Commissioner rejected the bid. The government held X liable for the difference between the bid offered by him and the highest bid accepted in the re-auction and commenced proceedings for the recovery of the sum. It was contended on behalf of the government of Delhi that X was under a legal obligation to pay the difference, as it was due to his default that a resale of the excise shop was ordered, and hence X was liable for the deficiency in price and all expenses of such resale which were caused by his default. Decide giving reasons whether X is liable to make payment to the Delhi government. Option A is no, X is not liable to make payment as the shop was sold to the highest bidder. Option B is X is liable to pay because the government of Delhi has to conduct re-auction and also suffered loss in the sale of the shop. Option C is X is liable because his bid was accepted but he failed to deposit the required amount on time. And option D is no, contract for sale was not complete till the bid was confirmed by the Chief Commissioner, and till such confirmation the bidder was entitled to withdraw the bid. The correct answer choice is D. According to the principle, absolute and unconditional acceptance is required to make a binding contract. The bid of X is only provisionally accepted subject to condition. At this stage, provisional acceptance does not make a binding contract because of these conditions. In this case, absolute acceptance was to be given by the Chief Commissioner, but before this happened, X did not pay, and hence in a way he withdrew the bid. Also, the Commissioner rejects the bid regardless, hence no contract has been created. Therefore, X is not liable to pay any expenses or damages. Now we move on to questions from CLAT 2016. The first question is principle. The communication of a proposal is complete when it comes to the knowledge of the person to whom it was made. Facts. A sent a letter making a proposal to B to purchase the house of B. The answer options are: Number 1, the communication of proposal is complete when B reads the letter. Number 2, the communication of proposal is complete when A sent the letter. Number 3, the communication of proposal is complete when B's wife received it. And number 4, the communication of proposal is complete when B's wife handed the letter over to B. The answer option that is correct is number 1. This is a simpler application of the principle. It can only come to the knowledge of B when he reads the letter and becomes aware of the offer. Keep in mind that we are talking about the communication of the proposal and not the communication of the acceptance. Question. The next question is principle. Acceptance of proposal must be the exact mirror image of the proposal. Facts. A made a proposal to B to sell the chair for Rs 500. B expressed his desire to buy the said chair for Rs 400. The answer options are: Number 1, it is not clear whether A made a proposal to B. Number 2, B has accepted the proposal of A. Number 3, B has not accepted the proposal of A. And number 4, it is not clear whether B has accepted the proposal of A or not. The correct option is 3. B has not given an unconditional acceptance and instead has made a counter offer. A mirror image of the proposal would be B accepting the offer for the amount Rs 500 as in the proposal. Now we move on to the next question. Principle. An agreement may be entered into orally or in writing or by conduct. Facts. A went to the shop of B and picked up a toothbrush and gave a check of Rs 20 to B and left the shop. The answer options are: Number 1, payment of toothbrush cannot be made through a check. Number 2, A did not enter into an agreement with B. Number 3, A should have carried a currency note of rupees 20 to make the payment. And number 4, there was an agreement between A and B. The correct option is number 4. The principle states that an agreement can occur by way of conduct. A picking up an item for sale and paying the requisite amount is his offer, which has been accepted by B impliedly because he does not object and lets A leave, keeping the check. Now we move on to questions from IELTS 2016. The first one is legal principle. The acceptance of an offer will be valid only if it is made in the way it was expected to be made. Factual situation. There was a telephonic discussion between J and K for negotiating the sale of a shop of the former to the latter. Upon reaching an agreement as to the price of the shop of J at rupees 20 lakh, J told K to send a letter to him within 2 weeks confirming that she wishes to buy the shop for the price finalized. 2 days thereafter, K gave her acceptance to J over telephone but sent the letter of confirmation after lapse of 1 month. Is J bound by the acceptance of K? The decision answer options are A. Yes, because the acceptance was conveyed within 2 weeks over telephone and it was followed by a letter of acceptance as stipulated. B. No, because although the acceptance was over telephone was conveyed in time, but it was not in the mode specified and the letter of acceptance was also not sent within 2 weeks. Option C. No, because sale of immovable property cannot be finalized online. Neither any acceptance can be given over any phone. Hence, the entire negotiation is invalid. And lastly, option D, yes, because no law can compel the purchaser to give his acceptance through the mode prescribed by the vendor. The principle gives you a qualification to the acceptance that it must be in the manner expected. The correct answer option is option B. In the fact situation, J made clear the mode of communication of acceptance to be through a letter in a 2 weeks period. Has a letter communicating the acceptance been delivered in 2 weeks? According to the situation, no, and hence J is not bound. It is the strict application of the principle. Further, for your information, for the purposes of legal awareness, Section 7 of the Indian Contracts Act 1872 requires the acceptance to be made in the manner prescribed by the proposer, which is the offerer, or in a reasonable manner if it is not so prescribed. Do not use this information to solve questions, however, you can use it for legal awareness. Now we move on to CLAT 2015 questions. The first question is, principle, agreements the meaning of which is not certain or not capable of being made certain are void. The facts are, a horse was bought for a certain price coupled with a promise to give rupees 500 more if the horse proved lucky. The answer options are A. This is a valid agreement. B. This agreement is void for uncertainty because it is very difficult to determine what luck, good or bad, the horse has brought to the buyer. Option C. The agreement is partially valid and partially void. And D. None of the above. The correct answer option is B. The rupees 500 for luck brought is very vague and it is not capable of being made certain, as adequately explained in the option. Alternatively, if the luck clause was made more specifically but not a wager, the agreement would have been valid. This is similar to the contemporary style repair question discussed earlier. A good trick to solve questions is to see which options follow or use the principle as a line of reasoning as much as possible. There were no questions from IELTS 2015 that covered introductory contracts. Thank you for watching this video. For more resources, follow, like and share our page LawSchool 101 on Facebook. Also, subscribe to our main YouTube channel by the same name. We encourage you to post your doubts, queries and questions in the comment section below. Best of luck, law aspirants.